Hi, everybody. Welcome. Sorry we're a couple of minutes late. Michelle and I were trying to work out a couple of technical glitches, but I didn't want to freak anybody out because of what happened last week. So really sorry that we had a last minute cancellation last week. I apologize. I should have been a little bit more on top of things. Michelle was under the weather, but we have a fabulous new backup moderator and who I really appreciate. And so we're all back in business. So welcome. If you happen to be new to the channel, my name is Lori Hellis, and I'm a retired criminal attorney. And I'm writing a book about the Daybell case. And every Wednesday we talk true crime. So welcome, everybody. So Michelle is kind of popping in and out because she's having a little technical issue with getting onto StreamYard, but we're going to get started, and I am sure that she will pop in any minute now. So thanks for joining us. We have a ton to talk about because we've been away for 2 weeks. Week before last, I was sick. Last week, Michelle was sick. It's the season. It's the season for colds and other cruddy things going around. And of course, it's the holidays, so everybody's really busy. And then on top of that, I'm also trying to get my book wrapped up. So had some great email conversations with my editor from my publisher, and that was super exciting today. And so we're moving along, and I am absolutely sure that we're going to be I'm going to be on time for my deadline the first part of January, and looking forward to heading down to LA to spend the Christmas holiday with my daughter and her family, her new husband and his family. And so that's all really exciting. I hope you all have wonderful plans for your holidays as well. And so thanks for joining me. Jennifer M. says she's looking forward to getting my book in her hands. Well, I'm looking forward to getting it into your hands. Let me give you a little bit of rundown on the schedule, the plan at this point. Now, things can change that aren't in my control, but for now, here's the plan. The plan is that I will get the bulk of the manuscript to my publisher the first part of January. And then there'll be a couple of updated chapters having to do with Chad and Lori's upcoming trials. So Lori's trial is scheduled for April 3rd in Arizona. And if Lori stays true to form, she is not going to waive her speedy trial rights. And Chad's trial is set for April 1st in Idaho, here in Boise. So we know that Chad's case is going to be live streamed. I think it's likely that Lori's trial will be live streamed as well. And so I think we'll all be popping back and forth and trying to cover all of those both of those at the same time. So that's exciting. Once I get the final updates to my publisher, it goes to print to the press in June. And it will be released and on the shelf in September, if all that goes according to plan. My plan is to do a launch event at CRIMECON the end of May. We'll have a booth, and we will be handing out swag and signing book plates for anybody who pre-orders the book. So I'm excited that I'm going to see a lot of you there. I've gotten a lot of messages from folks who are planning to go. I hope you'll all try and be there if you can. I know for some, it's a bit of a hike, like me, Idaho to Nashville. But for some of you, it might just be a quick trip. And I'd love to see as many of you there as possible and meet you all in person and get to give you all a hug. So the True Crime quilt is still hanging on the wall behind me, and we still have not finalized the drawing yet, but I promise I will do that and announce it. I just have gotten behind with all the other things that are going on. So let me Michelle's having trouble getting logged on. So, but let me get started and get into what we have going on. I am going to text Michelle and because she's still working on getting into the chat. So y'all behave yourselves until Michelle gets here. As if I ever had to say that to my community. It's so rare that any of you, there are any hard comments or trolls that I'm just grateful when you all are here. So we have 132 in chat now. I'm sure that'll pick up as folks continue to join us, but thanks for being here. And there have been some developments in the Vallow Daybell case that I want to talk about first, because that one's always near and dear to my heart. So we had a hearing a week or so ago, just before our last chat, so a week or so ago. We had a hearing, and the judge heard motions on several different issues that have been presented to the court. And for the most part, they ended up about the way that we expected. So the first thing I wanted to talk about, though, is Lori Vallow went to Arizona, which was really a surprise, because the Arizona officials had said that they were going to wait until after Lori's appeals, after Lori's appeals were exhausted before they moved to have her transferred. Now, I thought that was a bit of a mistake, because the longer it goes before a case gets prosecuted, the less likely it is that witnesses are going to the more likely it is that witnesses are going to disappear, people's memories fade. So you don't want to wait to prosecute cases if you can avoid it. So I found it surprising that Arizona had said they were going to wait. So I was stunned when they announced that Lori had made it already to Arizona. So apparently officials from law enforcement folks who routinely do inmate transportation drove from Arizona to Idaho, which is a 2-day drive, to pick her up and then take her back. They decided to drive rather than to fly because it's wintertime and there are a substantial amount of weather-related delays with flying. And I think they didn't want to run the risk of having of getting stuck in an airport somewhere or having any kind of flight delays that were going to cause problems. So they drove. They took 2 SUVs that were 4-wheel drive equipped and a female deputy, and they drove down to Idaho to Pocatello, and they picked her up and they drove her back, and she is in Arizona. She had her first arraignment and they set the trial date. It is kind of surprising that they've already set a trial date. However, we do know that Lori was adamant about her speedy trial rights the first time. So it will be interesting to see how that moves forward. I would expect that unless her attorneys file some sort of motion having to do with mental health, that trial will go forward. So, but we'll see. So she's been arraigned on murder and attempted murder for or conspiracy to commit murder for Charles and conspiracy to commit murder for Brandon. And so then on the 29th, we had this hearing for Chad, and John Pryor was there along with Lindsay Blake and Rob Wood. So the first thing that the judge addressed was the issue of cameras in the courtroom. Now, you might remember that during Lori's trial, Both Lori's attorneys and the state both said, we don't want cameras. And because they both agreed, the judge ordered no cameras. And so all we got was the recording that was released after the trial was adjourned each day. However, John Pryor has said from the very beginning, on behalf of Chad, that they want cameras in the courtroom. So I was not surprised at all when the judge, Rob Wood, again renewed his objection and wants cameras out of the courtroom. But I wasn't surprised when the judge ordered that there would be a live stream. Now, what the judge said was he did not want one of the commercial camera crews to provide the stream in a pool. He decided that it was going to be streamed the way that Lori's sentencing was live streamed through his YouTube channel. So, so that'll be the way it will look. It will look similar to the way it did in Lori's sentencing. Different courtroom, of course, because they're going to be in Ada County. So that was the other thing, was the prosecution asked the judge to consider moving the trial back to Fremont County. And it was absolutely interesting that that was something that they wanted to do, although not really a surprise, because the expense of the trial, there's no question that it's way more expensive to move the trial over here. They've got to pay for transportation and lodging, it's easy to forget that there's many more people involved than just the ones you see at the council table, because Fremont County has to provide some security. They have to pay to have Lori housed in the Ada County courthouse, or in this case, Chad. They would have to pay to have him housed in the Ada County court jail. They have to pay all the transportation. They have to pay, and it includes court and staff. So the judge and his staff, the prosecution and staff, defense and staff, they're all going to be paid for out of tax dollars. And it's a much more expensive proposition to have all these people traveling away from home, having to stay in temporary lodging, having to have meals away from home, all of those things. So it's understandable that Rob Wood decided that he was going to ask to move the case back to Fremont County, or in the alternative, to move it to a different location closer to Fremont County. So the judge said, we're way down this road. Ada County is already making tremendous amount of preparation for the trial in April. I don't see how Fremont County, with its 13,000 people population, is going to accommodate the number of jurors that it is going to take in order to get an unbiased jury. So the judge wasn't convinced. The other thing the judge brought up, though, was he said, you know, y'all didn't give me any new information, any new facts or figures. There were no new surveys. There was no new information that would lead me to believe that anything has changed since we had the venue motion, since I ordered the change of venue. So the judge determined that there was no basis to move the trial and denied that motion as well. So we will have cameras. It'll be live streamed through the court's YouTube channel, and it will still be in Ada County. Now, I have to tell you all, in spite of the fact that Judge Boyce and I got sideways and I had issues with being in the courtroom, I thought Ada County did a bang-up job of handling the number of people and the number of victims and the number of witnesses, and I think they did an excellent job. I have absolutely not one single complaint about how Ada County handled the trial. That being said, I think the judge just didn't see any reason to move the trial. So one of the things that Ada County had to do was they had to organize their docket around keeping that largest courtroom in the courthouse free during the trial. So understanding that Chad's trial could go substantially longer than Lori's did because of the death penalty piece and the fact that we're going to have a penalty phase, means that they are looking at somewhere between 8 to 10 weeks that they will not have that largest courtroom available to them. So they've had to move around their dockets, rearrange things to keep that courtroom empty and available for Chad's trial. So I think they've done a great job. I have absolutely no complaints about the way it happened last time, and I have no reason to think that they won't do a bang-up job this time as well. So the next motion was probably the most interesting from a legal standpoint, and that was that John Pryor filed a motion in limine. In limine is one of those Latin words we still use in the law. And what it means is he asked for a limiting order, an evidentiary order limiting the evidence that could come in at trial. And what he said was, when Lori's trial happened, it was the prosecution brought forward the theory that Lori really was the mover shaker, that things didn't get done unless Lori wanted them to, and that it was all Lori who did all the planning and all that. Well, we know that Chad's attorney really wants to bring forth the theory that Chad was sort of a witless dupe to the whole thing, taken in by his beautiful goddess who led him down the primrose path. We know that's where John Pryor wants to go. And so he wants to pin the prosecution down, saying, you can't now come back and say, oh, it was all Chad who was the mover shaker. So the judge reviewed some of John Pryor's motion and also reviewed some of the allegations that he had in his motion and some of the trial transcript, and came back and said that he did not believe that John Pryor had accurately pointed out points in the trial where the prosecution really brought forth that theory that Lori had been the mover and shaker. He agreed with the prosecution when the prosecution said, clearly, Mr. Pryor is misstating or doesn't understand the theory of conspiracy. So I agreed that in Lori's trial, when her attorneys came back and tried to bring an alibi defense, saying that Lori was not around when any of these things happened, and that the children died in Alex Cox's apartment while Lori was in her apartment, I said the same thing. How can that be? You can conspire anytime from anywhere. So at least on the conspiracy counts, there was clear evidence that they conspired. And there's no alibi for conspiring because you can do it anywhere, anytime. So similarly, in this case, in this motion, what the judge said was, in a conspiracy case, people can go back and forth between who is the person who's calling the shots. And just because the state brought forth the argument, pointed out the places where Lori was the mover shaker, because it was her trial and it was her conspiracy, they were pointing at her for her part in the conspiracy. doesn't necessarily mean that at some other point, Chad wouldn't have also been the person who was furthering the conspiracy. So the judge denied that and left it open for the prosecution to bring whatever arguments they believe are appropriate. Now, the judge did say that the issue could be raised again at trial if the state actually presents conflicting theories, because there is case law that says that you can't present a conflicting theory. For example, you have two people who were involved in a shooting and you don't know who actually pulled the trigger. And so in bad guy A's case, you contend he pulled the trigger and the jury finds him guilty. And then when you get to bad guy B, you can't now go back and say, oh, well, actually it was bad guy B who pulled the trigger. So that's a different kind of scenario than the one that we have here, where we're talking about parties to a conspiracy. So it's a little bit different, but the judge did actually leave the door open for John Pryor to raise the issue again if he felt like the prosecution was presenting conflicting stories. I had a question. Somebody asked me, can John Pryor write a book? Sure can. You probably will remember that both the defense attorney, Kirk Nurmi, in the Jodi Arias case, wrote a book, I think it had a couple of different parts to it. But John Pryor will run the same risk that Kirk Nurmi ran into. And that's what was that he was disbarred because the bar found that he had revealed client confidences in his book. So I guess the question is, if John Pryor decides to write a book, the most interesting pieces of it are going to be his conversations, the conversations he's had with his client. And those are all protected by attorney-client privilege. Now, could Chad waive that privilege? Potentially, but I think there's a real question about whether a waiver would completely cover John Pryor if he writes a book, a tell-all book. So I think John Pryor is going to have to be very cautious if he's going to write a book. Because the thing that would be most interesting about what John would write would be his conversations and his relationship with his client. And those are off limits. You are not permitted to disclose those things. And there probably is an awful lot that Chad Daybell would not want his attorney to talk about in a book. So I'm a little concerned about that. I'm concerned about it, about him doing any sort of public interviews, any sort of book, any sort of media appearances, because I think he could run the risk of compromising his attorney-client privilege. I've had that same question about Jim Griffin and Dick Harpootlian in the Murdoch case. They have given an awful lot of interviews. They were at CRIMECON. They have done a lot of, Jim Griffin has his own YouTube channel or podcast. So I have that same concern about them. I think the only thing that protects them is that South Carolina is such a good old boy network that it could take years for the South Carolina bar to actually hold them to account. I don't think that is the case in Idaho, and I think that it could be dangerous to John Pryor's career if he does decide to write a book. Chad Daybell cannot write a book. And the other thing that I think is going to be interesting is Chad Daybell has given something to John Pryor in lieu of attorney fees. We know he signed his house over. We don't know whether he's also signed over his book rights. But Idaho has a slayer rule, which says that a defendant cannot benefit from their crime. It would certainly be a benefit to Chad Daybell if his attorney, in lieu of attorney fees that he should have been paid, gets the rights to write a book. That's a benefit to Chad directly. And I think John Pryor could find himself awry of the Idaho Slayer law. So it's also called the Son of Sam law, and it precludes anyone who commits a crime from benefiting financially from it, particularly from through the media. So I think that is, I think that there's a risk. I think it could be really risky for him. Well, let's move on, because there are a couple of other cases that I really want to talk about. I want to talk a little bit about Delphi, because Delphi has turned into, dare I say, a shit show. And I think that it's not going to get too much better too soon. Interestingly enough, one of the, there have been several motions or writs of habeas corpus that have been put before the Indiana Supreme Court. And one of the issues had to do with whether or not these circumstances, let me drop back a little bit and see if I can simplify this a little. So in order to file an appeal with an appellate level court, you have to have an underlying cause of action. You have to have an underlying case. And you have to have a decision in an underlying case that you can appeal to the court. So the problem is that Judge Gull, in that case, removed these two lawyers and found them to be grossly negligent. But that is not an order from which you can get appellate relief. So they had to go, they couldn't use that as the procedural avenue to get this before the Supreme Court until after the case was completely decided. Then they could, but they couldn't get what's called interlocutory relief. So relief that happens before a final verdict in the case. So they filed a writ of habeas corpus, and they, even at that, they had to rely on an exception that gets them into the Supreme Court. It's a fairly narrow exception. And so they had to get over that hurdle before they could get the Supreme Court to consider any arguments about reinstating them. Well, the Indiana Supreme Court has been inundated with amicus briefs and other people who are filing on their behalf. And so a day or so ago, the Indiana Supreme Court said they would take up the case, and they're going to hear the appeal of the dismissal of the attorneys, Rosie and Baldwin, and the motion to remove Judge Gull on the 18th of January, which is a pretty quick turnaround on a Supreme Court case. They have also asked the Supreme Court to order the court to set the trial no further out than 70 days after their decision. So they're asking to accelerate the court date, because when Judge Gull took Rosie and Baldwin off the case and appointed two new public defenders on the case, she then set the case out, which was set to go to trial in January. She set it out until next October. So they are now saying, we want that date accelerated. We don't want to wait till next October to try the case. So that's going to be very interesting, and we'll be keeping an eye on that. If you are at all interested in that case and a deep dive into that case, do follow Bob and Ali Mata. I will put the links in our show notes. Do follow Bob and Ali Mata, Motta, and their channel and their podcast is called Defense Diaries. And Bob is a defense attorney. Ali is a defense attorney as well. And they have done some great work. He has a very interesting series. His father was the defense attorney that defended John Gacy. And his father had recordings of his time with Gacy. And when Bob was 18 or 21, I can't remember, his father gave him those recordings. And so he has an entire podcast season of talking about the Gacy case and illustrating it with those recordings. It's really fascinating. He's also been very interested in continuing to investigate whether or not there are other Gacy victims that have never been identified. This is very similar to Kerri Rawson and the BTK case. And Kerri Rawson is BTK's, Dennis Rader's daughter, and she has been very involved in identifying additional victims of BTK. So those are a couple things that you might be interested in. Bob and Ali have also been doing a recap of the making of a murderer, Stephen Avery, that case. And they've had some really interesting information about that as well. So if you are looking for something over the holidays or while there's a lull in some of the other cases that you're following, give them a listen. The other thing I wanted to talk about is Ethan Crumbley was sentenced. Now, Ethan Crumbley was the student who opened fire at his high school, at Oxford High School. What has made this case unusual has been the fact that the state has also charged his parents under the theory that they knew that he had severe mental health issues. And in spite of that, they bought him a better gun and ammunition. And on the day that the school brought to their attention that he was making troubling drawings and saying troubling things, they left him at school with the gun in his backpack. So that is really a case of first impression, meaning that it is not a legal issue that has been reviewed or has previously been brought. So it's interesting from that standpoint. Can parents be held criminally liable? Now, there's no question they can probably be held civilly liable, although there's a big question about whether or not they have any assets that would make it worth going after them. But do they have, is there a basis to go after them criminally? Sorry, I'm a little raspy, but you guys are used to it by now. So in Crumbley's case, he was 15 when the case was brought. And the judge recently had what they called I think they called a Miller hearing, meaning that he was remanded to adult court because he was 15 and it was a violent crime. And in that state, that is justification to remand a youth to adult court. So he was remanded to adult court, but the question was whether under the law, he could be sentenced to life without parole. In general, youth cannot be sentenced to death or to life without parole, because the law recognizes that young people commit crimes when their brains aren't fully formed, and that they have a much greater opportunity and a much greater possibility of being reformed and rehabilitated. So in recognition of the fact that it's more likely to be possible for a young person to be rehabilitated. And in recognition of the fact that a young person's brain isn't fully developed at age 15, the state requires that the court hold a hearing at which the judge decides whether or not he can life without parole could be imposed. So they had that hearing. Some of you may have caught some of it. They had that hearing. The judge did find that it was possible to impose, or it was appropriate for him to be eligible to have that imposed. They did a pre-sentencing investigation, and then they had sentencing today, yesterday, I think. And the judge heard from a number of victim impact statements from the families of the 4 students that died in the shootings, from students that were injured in the shootings, from students who were there and now suffer from PTSD. And after all of that, the judge did impose life without the possibility of parole for Ethan Crumbley. If you would like an interesting listen, definitely take a listen to Ethan Crumbley's statement to the court. I think that first of all, I think his attorneys did an excellent job of preparing him to make that statement, but he also took complete responsibility. Now, undoubtedly, he did that because he's hoping to spare his parents from criminal liability in the case. But I thought that he gave a very heartfelt statement saying that he believed that he, at the time that the crime was committed, that there was no one but him to blame, that he is not a good person, and that he hopes that with time and effort that he could become a good person, but very accepting of living the rest of his life in prison. So I thought that was very interesting, particularly in light of Charlie Adelson's sentencing, and Charlie standing up and saying, "I'm maintaining my innocence." So it was interesting to contrast those 2 defendants at sentencing. So, and that leads us right into Adelson. So Charlie Adelson was sentenced. The mandatory sentence in Florida for murder is life without parole if the state hasn't sought the death penalty, which they did not. So there wasn't any leeway for the court to say, well, could be a nice guy, or there wasn't any way that the judge could do anything but sentence him to life without parole. It was a very short and sweet sentencing. Phil Markel, Dan Markel's father, in all of the trials we've heard so far, the Sigfredo and Lewis and Katie, all of the prior trials, we've heard from Ruth Markel, Dan's mother, and his sister. But his father is kind of a soft-spoken guy and kind of tends to be a little bit more in the background. But he gave the victim impact statement at Charlie's sentencing, and it was incredibly moving and very sad and very heartfelt. And so it was great that he had the opportunity to have a voice and to be heard. So probably the most interesting thing, though, is the issue of Donna Adelson. So for those of you who aren't familiar with this case, I'm going to give you a really quick rundown of a very complicated case. So Professor Dan Markel was a Florida State University Law School professor. He was a Harvard trained lawyer, and he was a tenured professor at FSU. He was he was a criminal law professor and a writer on criminal theory. Really interesting guy and very, very scary smart. He met and married Wendy Adelson. She was also an attorney. They met just after or just as she was finishing law school. They were not in law school at the same time. Dan was a little older than Wendy. So they met, got married, had 2 little children, 2 little boys. And Wendy decided that one of the things that was difficult for Wendy was she was born and raised in the Miami area. And when Dan moved the whole family to Tallahassee up north, in Wendy's mind, it was moving to the sticks. And she hated Tallahassee and she wanted the hell out of there. When she divorced Dan, she wanted to move back to the Miami area because that's where her family was. And they're you will hear, a very enmeshed family. So she filed a motion with the court. Now, she and Dan shared custody of these 2 little boys equally, but she filed a motion with the court asking permission to move back to Miami. Now, the state of Florida is enormous, and it's like California, it's huge. And so the distance between South Florida, where Wendy's family lived in Miami, and Tallahassee was a good 6-hour drive. And Dan Markell said, I don't want my children that far away. I'm a half-time parent for them, and I don't want to suddenly become an every other weekend, if I'm lucky, kind of a dad. And the judge agreed and told Wendy she could not move. Shortly after that, Dan Markell was murdered in his driveway. And as it took a substantial amount of time to investigate the case, but eventually law enforcement, through some really good police work, discovered that 2 Latino men had driven from Miami to Tallahassee and murdered Dan in his driveway. And they were able to track these 2 people back to a woman named Katie Magbanowa. Katie Magbanowa was Charlie Adelson's girlfriend. Now, Charlie Adelson is Wendy Adelson's brother. Wendy Adelson, then the day after Dan Markell was murdered, took her children and went to Miami and never went back to Tallahassee. So law enforcement was able to connect these dots up and discover that their parents, Donna and Harvey, were also involved. And the way they did that was they started doing wiretaps. And they wiretapped the conversations between Katie and Charlie, Charlie and his mother, Donna, and they were able to connect up the dots. And it is apparent that Donna Adelson and Charlie Adelson, at a minimum, were involved in plotting to have Dan Markell murdered. And that Charlie Adelson then enlisted the help of Katie Magbanowa, his girlfriend, and she then went to these 2 guys, one of whom was the father of her children, to have them commit the murder. So it's a fascinating chain, all dating back, going back to this really domineering matriarch. Now, to me, it has a lot of parallels to the Piketon case, to Piketon, Ohio, and my mind just went blank. Watson? Somebody will tell me here in the chat in a minute. So anyway, there's some interesting parallels with that case because both of them having very domineering matriarchs in grandmothers who absolutely want their grandchildren at any cost. So now where the case stands is Charlie Adelson was recently tried and convicted and sentenced to life without parole. And a week after he was convicted of murdering, hiring the hitman to murder, was convicted of murder for Dan Markel. She was apprehended at the airport with a one-way ticket to Vietnam that has Vietnam, which has no extradition treaty with the U.S. Now there have come now they have released a bunch of jail calls between Charlie and his mother that are incredibly incriminating. So she was arrested literally on the jetway, getting on an airplane to fly away with a one-way ticket to Vietnam by way of the Middle East, Doha, Qatar, I think. I'm not positive, but yeah, pretty interesting. So, so now they put her in jail. They arrest her in Miami. They transport her back to the dreaded Tallahassee that they all hate. And she is in jail in Tallahassee and appearing in court there. So her Dubai, that's right. Thank you, Kathleen. This is what happens when I write all day and my brain feels a little scrambled. So anyway, she was arrested, taken back to Tallahassee. When she had these phone conversations with Charlie, she was talking about the fact that if by chance she couldn't get out of the country and to some place with no extradition, she intended to commit suicide. And she talked at length about a plan. And so she's been on suicide watch. Well, when she got to Tallahassee, they promptly put her into an observation cell. And an observation cell means you have virtually nothing. You have a blanket and maybe a sleeping pad on the floor. You don't get any utensils to eat with because you could use them to hurt yourself. You have to eat with your hands. I mean, it's not fun. It's not fun to be in a mental health hold in a jail. But it's doubly not fun if you happen to be as incredibly entitled and wealthy and entitled, I guess, as Donna Adelson. So I thought just for fun tonight, we would go through the motion that they filed asking for emergency relief for Donna. Because I just think it is really interesting. So I'm going to pull up the motion and give y'all, and I hope that I don't know if I can make it bigger because this is not something I've used before. So, but we'll try and go through it together. Forgive me if you start looking at my face far too close. But it says, Donna Sue Adelson, pursuant to the United States Constitution, hereby moves the court to enjoin the Leon County Jail from subjecting her to her current conditions of confinement and directs the Leon County Jail to place her in a unit where she can prepare for trial and speak to her family or conduct an independent psychological evaluation in order to be placed in a different unit where she can properly prepare for trial and speak to her family. Alternatively, she requests to be released on house arrest. And in support, she states the following. So I'm not going to read the whole thing because I hate it when people on YouTube read everything to you, but I am going to sort of hit the high points. So she talks about she was arrested in Miami. She was placed in a psychiatric unit, and she was assessed there, and then according to them, she was cleared and then moved into some other sort of general population. Now, her attorney complains that because of all the restrictions, because of her psychiatric hold, she was not able to meet with her client as freely as is needed to prepare for a trial. So there doesn't seem to be any indication that her mental state had deteriorated since she was moved from Miami to Tallahassee. But she contends that when she arrived, she was put in a small solitary cell with a toilet and a sink and a mattress on the floor and a dirty blanket. She asked for a book or a Bible, but hasn't been given anything. The day after she arrived, they started asking her about her medications. But get this, now she's in jail, right? So a jail staff member comes up to her and says, I need to talk to you about your medications. She says, who are you? Essentially, she says, they wanted to talk with her about what medication she was taking before she was arrested. Donna felt uncomfortable during this interaction because she couldn't see the official's face and wanted to verify that they were, in fact, a healthcare professional. But the official wouldn't verify that. So when Donna said she was concerned, the official told Donna that she's a fancy white lady who murdered her son and now thinks she has rights. The official joked with other guards outside of her cell, continuing to talk about her learning that the fancy white lady murderers have no rights here. So, and then saying to her, do you see where you are and where I am? I'm out here because I'm not a murderer. Now, I want to say, if this is true, it's wrong. There is absolutely no excuse for jail staff behaving that way. There certainly is a line that jail staff are not allowed to cross. If this is true, jail staff should be reprimanded for that kind of behavior. I do understand that the Adelsons have been very outspoken about their dislike for Tallahassee. They've been very outspoken about their feeling that they are backward and it's the sticks. And I guess I couldn't blame somebody for feeling a little offended that their community was being sort of portrayed as this backwater place. However, that's no excuse for ever mistreating someone who is under your care and who is helpless. So regardless of what you may think about Donna Adelson, and believe me, I have my opinions, it is still never okay to abuse someone who has absolutely no power and is absolutely under your control. And nowhere is that more clear than in a jail. So if that happened, it was absolutely wrong. Now, did it happen? I don't know. But Donna Sue at this point definitely wants to see the manager. So there are a lot of very funny memes out there right now about Donna Sue asking to see the manager and being a Karen. So then she goes on to complain that her blood pressure medicine has been withheld. Now, it may very well be because she wouldn't talk to the person who came to ask her about her medications, but we don't know for sure. It was only with the help and intervention of the state that she was allowed to talk to her attorney. Now, her attorney at the hearing that they had on this motion backtracked a little bit and said that she could, in fact, have contact with Donna. Here's the problem. The problem is that most calls these days go through tablets. So there's some sort of a tablet that the inmates use to make their calls. The issue with that is that the sound on the tablet goes through headphones that are wired. And if you are in lockdown and on suicide watch, you can't have a wire that you could strangle yourself with. So That's been the problem. The issue is, sorry, got distracted by the chat, which is why I try not to read it when I'm doing lives. But the issue is that her attorney is an attorney out of Miami, which means that she needs to make contact with her client by some kind of electronic means. So because the typical calls go through a tablet, it took Georgia Kappelman, who is the prosecutor, getting involved and arranging with the jail for her to have phone contact with her lawyer. And she complained, and probably rightfully so, that in order for her to have contact with her lawyer, she had to do it over a speakerphone. Again, this has to do with the fact that she can't have things with cords. So she can't talk on the telephone with a cord. She can't, and so it required that she put her lawyer on a speaker, and there was a deputy in the room. That's also required because she's on suicide watch. So I'm certain that at some point these restrictions are going to be relaxed in some way. But for now, I understand that it's a handicap. Unfortunately, what that means is that her Miami lawyer is going to have to get go the 6 hours down to Tallahassee and meet with her in person. And I understand that for someone who has a busy law practice, traveling 6 hours every time you want to see your client is a hardship. But I'm pretty sure that Donna Sue can afford to fly her down there anytime she wants to see her. So I think this is going to be an ongoing issue with Donna Sue, because I think that she is going to want way more access to her lawyer than is going to be available to her. So, and in the dreaded Tallahassee, no less. So the hearing was very interesting. The judge was not at all sympathetic to the fact that the attorney was complaining about access to her client. Now, I do understand that a lot of the discovery lawyers get these days is on jump drives. It's all done electronically. And the only way that you can go over that information with your client is to have some sort of electronic device to access it. So whether it's a tablet or a laptop, there is an issue with having access to your discovery. What that usually means is that somebody is going to have to go there and sit with her and go through all of that information. And we know that there's a lot of it. There are hundreds of hours of recorded telephone calls. So it is a big ask to have a client that's in custody and have this volumes of discovery. But lawyers deal with that every day. So her lawyer has got to know how to do that. And the fact that she doesn't usually practice in Tallahassee and doesn't have relationships and have contacts within the Tallahassee jail is probably working to her disadvantage. Because when you're a lawyer who regularly, particularly if you're a public defender and you're in and out of the jail all the time, you know the jail staff, you know the regulations, you know the way the process works, and you are able to get assistance from the jail in certain circumstances, in ways that another lawyer who doesn't know everybody and that they don't know might not. Because if you have a reputation as a lawyer of following the rules and of making sure that you're protecting your client's rights at the same time, but you've got a good reputation with the jail of being a lawyer that doesn't cause trouble, then when you really do need something, they're going to bend over backwards to give you a hand. On the other hand, if you happen to be a big city lawyer who thinks Tallahassee is the sticks, and you come into the jail demanding access to your client, you're probably going to get the minimum because they're not going to bend over backwards to help you out. That's just human nature. I mean, it's about building relationships that later become an integral part of your practice. It doesn't matter what job you're in. the importance that the ability for you to get your job done is directly related to the relationships that you have in your industry, in your office, in your work team. So, so Donna Sue at this point had asked the judge to allow her to have an independent psychological evaluation. Well, that doesn't happen either, because the judge said, first of all, I don't have any authority to tell the jail what to do. Second, I don't have any way to make available, to force the jail to make you available for a psychiatric evaluation by an independent psychiatrist. The jail staff and the sheriff were there and said they are evaluated daily on whether or not they present a continuing threat to themselves and whether or not they can be released into general population. So I expect that these restrictions are going to get relaxed, and I expect that she is going to be moved into general population and have more of an opportunity to meet with her lawyer and more time to be able to go through some of those videos and all of the discovery. But it is interesting, if you watch the hearing, she was dismissive and rolling her eyes and sighing and arguing out loud and all the things that you don't want a client to do. So she was very clearly acting like the privileged white lady with lots of money who is not accustomed to being told no. And I think that is really at the heart of the Adelson case. This is a family who were never accustomed to being told no. And as a result, when they were told no by a judge who said, no, you can't move your grandchildren 6 hours away from their father, they just figured that they'd find a different way. And their different way was to take out the guy who was the stumbling block in the case. So really, really fascinating case. There's a lot about this case that is of interest to me. I'm thinking about the possibility that this could be my next book. And if it was, it would really sort of also contrast the Piketon case and really sort of dig into the whole issue of matriarchs and those kind of overbearing, controlling grandmothers who are running the show. So stay tuned. There may be more information. There was a case that a couple of people asked me about. It is Jessie Kerchevsky. She was on trial. It was the case where she poisoned a woman who she was taking care of using eye drops. She was found guilty, and as her sentencing was scheduled, she then, it was discovered, was sending letters out trying to get somebody to create an alibi for her, creating false documents, creating it's like 35 plus page letter that she sent to these people. She claims that she gave it to her lawyer who delivered it. Her lawyer then promptly said, I need to be out of this case because she's lying. And so it ended up that the judge did let the lawyer withdraw from the case and has postponed her sentencing in order for there to be a new lawyer appointed. But she was, it really amounted to her trying to perpetrate a fraud on the court and trying to loop her lawyer into helping her perpetrate a fraud on the court. Now, if her lawyer did in fact take the letter out of the jail and circumvent the jail's process for mail, that could be a big problem, and that lawyer could be in a lot of trouble. The lawyer denies that that happened, and you know, there's an investigation going on right now, and I'm certain that the jail will get to the bottom of it, because everything is taped and copied and videotaped. And so I'm certain that there will be a resolution to it. But in the meantime, her lawyer's off the case and the sentencing has been set over. And then lastly, I wanted to talk a little bit about Murdaugh before we take questions. Initially, we heard Dick Harpootlian and Jim Griffin, or as I affectionately refer to them as Pootie and the Grifter, filed motions for a new trial based on juror misconduct. And what they said was that that the clerk of the court, Becky Hill, who wrote a book about the behind the scenes in the trial, had unduly influenced the jurors. She had made comments to the jurors in ways that could potentially have influenced them. So initially, it sounded like, no, this was a little bit of sour grapes, and like they were going to have a real hard time proving that there was actually that even if it happened, that it impacted the outcome of the trial. Now, there's an argument, legal argument, over whether the test is, could it have impacted their outcome or did it? So that's a big difference. So Pootie and the Grifter say that the case law says that they only have to show that it could have impacted the jurors' decisions. The state says, oh, no, you have to prove that it actually did impact their decision. So that'll be the first question that'll have to be asked. Now, Judge Newman has recused himself out of the murder portion of the case. Alec Murdaugh recently entered a guilty plea in all of the financial crimes and is set to be sentenced to an agreed 27 years. He still has not been sentenced in the federal crimes, the federal cases having to do with all of his theft. So there's still a lot of things hanging fire in the Murdaugh case, including the issue of whether or not there's going to be a new trial. But in the meantime, problems have begun to mount for Miss Becky, who is the clerk of the court. Her son, who was the IT expert, the IT manager for the courthouse, no nepotism there, was arrested for illegally wiretapping telephone conversations in and around within the staff of during the trial. We don't know a lot about this case yet, other than the fact that that it's starting to come down on Miss Becky, because one of the things they did was they seized her phone as well as her son's. So we really don't know what those can have contained, but we do know that the case has been referred to SLED, the South Carolina Law Enforcement Division, which is their state police, for investigation. So it does appear that Miss Becky's problems are continuing to mount. In addition, there has been a state ethics complaint filed against her, having to do with her behavior during the trial. So she's probably in a little more hot water. We don't know for sure whether this has anything, the ethics complaints have anything to do with the fact that she wrote a book, but I had some real questions about that from the very beginning. So we do know that there are complaints that she was giving out courthouse tours in return for donations. And there's been some question about where those donations actually went. She originally said it was to replace a big front window in the courthouse, but there's some substantial concern about where that money went, that people donated in order to get tours and be able to sit in the cell off the courtroom where Alec was housed during the trial. So those will all be very interesting things. Mandy Matney from what was known as the Murdaugh Murders podcast is now called True Sunlight, and her co-hosts for their spinoff podcast, which is called Cup of Justice, that she does with Liz Farrell and Eric Eby. My brain just, he is the attorney who has represented many of the victims in the Murdoch's case, including this Satterfield. So if you are interested in that case, definitely go and give those things a listen as well. So we're at the 1 hour mark, and I would love to start taking some questions. I'm going to have a little sip of red wine. I've been sort of limiting my consumption. It's not on my meal plans. However, tonight's the night for a glass of wine. So, and thank you for all of you that gave us your good wishes about having the crud a couple of weeks ago, and all of you who have made nice comments about my weight loss. I'm down about 70 pounds now, so thanks for noticing. And entirely intentionally. Hey, running on empty. So who did Donna Adelson think she was asking about her health? The janitor. Who did Donna Adelson think was asking her about her health? The janitor? Give me a break, Donna. You're an entitled Karen. I cannot disagree. There is a guy out there. He has a channel called Court Jester, I think it's called. And his name is Jay, and he has nicknamed her Grandma Gotti because he feels like the Adelsons are sort of the South Florida crime family. So I can't disagree. I think that Donna has had a very rude awakening in the last couple of weeks being in jail. And I think that Georgia Kappelman thinks that her case is good, or she wouldn't have arrested Donna. And so I think Donna should get used to those concrete walls, because I don't think she's getting out of jail or prison anytime soon. The other thing I think is that the people who, the folks who have been saying, oh, she's 73 and she's so frail and she's, you know, she's delicate, and we don't, yeah, she's as delicate as a bomb. I'm sorry, but she is not delicate. She is tough as nails, and she has expectations for how she's going to be treated. And I think that she's running into a rude awakening on it. So I can't disagree. I think that she is a bit of a Karen. Hi, Kathleen. Thank you so much. I want to remind everyone while we're talking about this that all of your super chats, all of your donations to the channel go directly to our moderator, Michelle. And for those of you who might not know, Michelle has been receiving chemotherapy for blood disorder, and she's had a rough go of it. So I appreciate anything that you, and I know she appreciates it more than she can say. I appreciate any support that you can give Michelle, especially over the holidays. So thank you so much, Kathleen. I appreciate you. I appreciate the fact that you support the channel. I do see you when you support other channels as well. So I know we're not the only one that you support, and I do appreciate it more than I can tell you. You are always very generous. Likewise, Mary Howard, who is also always very generous to Michelle. So thank you very much. I am going to pop this out and get back to full screen so that I can actually see all your questions. Lisa, always, do you think the wife of Rex Heuermann is a participant in his deviant behaviors? Well, I think there's some evidence that they were swingers. I think there's evidence that that they were participating in they had an open marriage, that they were participating in those sorts of sexual activities. Now, does that mean that she also was aware that he was committing murders? Let's remember, first of all, that he's innocent until proven guilty. He has not been convicted. Does her participation in that sort of activity mean that she knew if he was committing murders that he was doing that? I don't think we have enough information yet. I understand that it's easy to jump to a conclusion having to do with his wife, Asa is her name, particularly since she recently signed a deal with Peacock to do where she will benefit financially to do a series. First of all, I'm not convinced that Peacock would enter into a deal with her if they thought that she was somehow implicated in the crime. There was a big hoo-ha recently in the last couple of weeks about her DNA being linked to a crime scene. That is not new information. We have known since the bodies were discovered that that a hair found on one of the bodies was linked back to her by its DNA. We know from the Lori Vallow trial that hair is easily transferred. I mean, we all lose hair every day, some of us more than others. And that hair can be easily picked up and transferred by somebody who's in your home. You don't even have to be in close contact with them. They can pick it up off the bathroom counter or the rug in the living room. So the idea that a hair was linked by DNA evidence to her probably is of very little import. It suggests that the victim was in her home, and we know from some of the things that we've learned since then that at least one of the victims was in their home. So I'm not sure that we could jump to the conclusion that she was in some way complicit in the murders. Now, it's possible that she could have known what he was doing. It's possible that she could be some sort of accomplice after the fact, that she knew that he was doing these things and for whatever reason decided not to say anything. I think we don't know enough. We don't know enough about their relationship, about the power in their relationship. We don't know enough about any of it to be able to jump to that conclusion. But I think we know at this point that there's at least one witness out there that says that they lived that swinger lifestyle, that they frequented places where those kind of behaviors, those kind of activities were happening. I don't think we know enough about what that means. So I'm not going to rush to paint her as anything but a victim at this point. That could change. I mean, information could come out that could clearly link her to this to his activity in a way that that is incontrovertible. But you know, we know in other cases that wives have been. I think one of the famous cases that was involved in the Mindhunter series was Jerome Brudeau's. He was from Oregon, so I know a little bit about his case. And he kidnapped women. He abused them in his garage. The home had a separate garage. It was an older home that had a separate garage. He used it as a photographic studio. He was a photographer. And he absolutely forbid his family to have any, to open the door or to go in there at all. I think similarly, Carrie Rawson would say that her dad, the BTK killer, Dennis Rader, did exactly the same thing. He exerted a tremendous amount of control over his family, and there were places in her home that were absolutely off limits to anybody but dad. And so what happened in those spaces, we don't know. He exhibited a tremendous amount of control over his family, and so they were unaware of what was going on, sometimes just feet from where they were or in the home when the rest of the family was gone. So I'm not prepared at this point to jump to the conclusion that she was somehow involved in the murders or involved in covering them up. But I think we do have some evidence that she was involved in that lifestyle, and that it was a byproduct of that lifestyle that he was able to lure women who were sex workers into his sphere of control. So, good question. And I think it is unanswered at this point and probably going to be unanswered for a while. Hi, Jenny Pajama Pants. Did you notice? You weren't supposed to know I had my pajama pants on. That is the beauty of only being filmed from the neck up. Why do you think Chad is bringing this case to trial? How can he have any hope after seeing Lori's trial? Hubris or something else? This is a really great question. I think that it is possibly a combination of hubris and naivety. Having a little trouble here tonight. Because I think that Chad is naive enough to believe that if he did not, and he seems to have this mindset that if he did not put his hands on these murdered people, that he somehow is less culpable and less responsible. Now, remember, he has an experienced lawyer, but his lawyer is still obligated to make the arguments that his client intends him to make. His client is ultimately in charge of making of how the case goes forward. So John Pryor is having to stand back and say, my client says he was framed. My client says that his only crime was in believing Lori and in being totally head over heels with the sex goddess. And that it is completely, was completely her and Alex who were responsible. Now, that plays very differently with Lori, who believes that Chad is her prophet and who thoroughly believes to this day everything that Chad said. So I think we're going to see Chad throw Lori under the bus, undoubtedly. I think we're going to see John Pryor make the argument that he was nothing more than a poor, abused, misled pawn, and that he did not know the children were buried in his backyard. And as his daughter Emma said, he was framed. Now, I think they have a fundamental problem, and that's how they explain Tammy's death. Now, I think Chad is going to go into court and say, Tammy died in her sleep. I had nothing to do with it. It was purely a natural death, because that's the only thing he can do. He cannot explain how Tammy died any other way. He and his son Garth, who was in the room across the hall, are the only two people who were in the house at the time that Tammy died. We also know that Alex Cox was a mile or so away in a church parking lot, and that's where his phone stayed. So either he left his phone in the car and walked the distance to Chad's house to help Chad carry out the murder, or he was there as backup in case Chad couldn't go through with it. Don't know which one of those scenarios is correct, but nonetheless, Chad was in the house when Tammy was murdered and knew it was happening and was an accessory to it if he didn't do it himself. So I think that's the place where they have the biggest burden, the biggest hurdle. And I think that he's going to just stand on his argument that Tammy died in her sleep of natural causes, even though we have after the exhumation, we have a medical examiner who says completely opposite, that she died of suffocation, and that the pink foam that came out of her mouth and nose afterwards was proof that she died of suffocation. I think John Pryor is going to bring in experts who are going to say it is possible that she could have died naturally of suffocation, and that pink foam could be caused by natural forces. I think it's clear that Lori believed that that Tammy somehow died of complications from medication. She, in her allocution after her sentencing, said no murders happened. Suicides happened, accidental deaths happened, deaths because of complication from medication happened. So those three things, if you stand back and say, well, who did what? I think Lori was alluding to the fact that Tylee committed suicide, that JJ's death was somehow accidental, and that Tammy died because of complications from medication. So, I mean, I could be wrong, but that's the way I lined it up in my head when she said those things. So if that's the case, then I think that we're going to see John Pryor bring in experts that say that Tammy's death could have been from natural causes, and still, given the findings that the medical examiner found in their examination when she was exhumed. So I think we're going to see a much more vigorous defense, a very robust defense that we didn't see in Lori's case. And a lot of that was because Lori was driving that and told her attorneys, you can't throw Chad under the bus, you can't blame Alex, and you can't blame my mental health. Taking those three things off the table meant there really were no more alternatives than to do what they did, which was to stand up and try and poke holes, reasonable doubt holes in the prosecution's case. And the prosecution put on a very confident, very well organized case. So it will be interesting to see when Chad's case comes along, how very different his defense is. I think we're going to see a different prosecution as well, because I think we're going to see one more targeted at Chad's involvement in the conspiracy. And that, just by definition, is going to be different. So this is a great question. I think that he believes that. And let's remember that as long as the death penalty is on the table, he doesn't have anything to lose and everything to gain, because he may very well be able to convince the jury who's also going to hear the penalty phase that they shouldn't impose the death penalty, that somehow he's less culpable. So remember that his defense team not only is dealing with, is he guilty or innocent, but they really are having to look farther down the line at setting themselves up for a penalty phase where they can say he's less culpable than Lori, and Lori didn't get the death penalty. So, hi, Rosat. If Chad and Lori's trials clash, how will that affect potential witnesses that could be called for both cases? Well, this is a good question as well. I love the fact that you guys are asking these questions. You guys don't ask the softball questions, because we've already been through those and we've already educated you about the law enough that you're asking the questions about the nuances of how the trial is going to go. And that's fun and challenging for me. So this is a good question, because the prosecution's only going to call the witnesses that prove their theory of the case. Now, the prosecution knows that these witnesses have already testified, and they're not going to put the witnesses in the position of having John Pryor have the opportunity to come at them and say, yes, but haven't you previously testified to this? So they're not going to put those witnesses in the situation of John Pryor being able to impeach them with their prior testimony. That would be foolish on the part of the prosecution, because it would weaken their case, and it would also be damaging to the witnesses' credibility that they need those witnesses to be credible before the jury. So I don't think you're going to see a tremendous amount of them changing their theory of the case. I don't think their theory of the case has changed at all. I do think you're going to see some subtle nuance in the way they approach the case, because they are going to be bringing more out about Chad's participation in the conspiracy, because it's the conspiracy that convicts all of them. So while I see John Pryor's point that the prosecution is absolutely precluded from bringing a completely different theory of the case, if at this point the prosecution were to go into trial and say, at Lori's trial, they said, we don't know who actually ended the children's lives. We don't know that. We don't know whether any of the people who were involved in this conspiracy were actually the ones who put hands on the children and ended their lives, or put hands on Tammy and ended her life. We don't know that. If they were to now go to Chad's trial and say, we absolutely believe that Chad Daybell put his hands on one of these victims and murdered them, that is a completely different theory of the case, and that would not be allowed. However, for them to go into the trial and emphasize the role, more of the role that Chad played in the conspiracy, is permissible. So although the trial is going to go forward in probably a way that we would expect, having seen Lori's trial, I think we're definitely going to see a different focus and a different emphasis on some of the same evidence. So where we saw in Lori's case an emphasis on her communications with people, I think we're going to see the emphasis be on Chad's communications. I think we're going to see much more about Chad's communications with Alex, particularly around the nights that these incidents happened. We have not seen anything. And remember that there was a substantial amount of information redacted out of the Gilbert and Chandler data dumps. So it may very well be that there are text messages between Alex and Chad that we have not seen yet. Now, the defense will have seen them because the prosecution is required to provide all that information to them. But there may be messages, text messages back and forth between Alex and Chad that we haven't seen yet. So it remains to be seen whether they're going to have different information to present to the jury than they presented to in Lori's trial. That remains to be seen. But I think we can expect that their focus and their emphasis is going to be in a different place. Good question, Roz. Hi, Karen Rowe. Okay, good question. So here's the difference between, and we've talked about this before, but it certainly bears repeating. When a person retains a lawyer, it is their responsibility, because they're paying the lawyer, it's their responsibility to vet that lawyer, to determine whether or not that lawyer is qualified to represent them. And it is their responsibility to hire the lawyer that they can afford, that is best qualified to represent them. That is different than if the state, I'll get to that question in just a second. It is different than if the state appoints a defense attorney, because in that case, the state has the right, because they're the person paying the lawyer, to insist that that lawyer meet certain minimum qualifications. So because John Pryor was retained by Chad and has never been appointed by the state, he did not have to meet those same minimum requirements. It was up to Chad to decide whether or not John Pryor was qualified to represent him. Now, the best of my knowledge, John Pryor has been has assembled a team. He has a mitigation specialist, and he has been, at least at a minimum, consulting with with experienced death penalty attorneys. But John Pryor is where Mark Means wasn't experienced in criminal law. John Pryor is a very experienced criminal attorney. He understands the constitutional arguments, the criminal process, the way that cases are determined. I mean, he understands the fundamental criminal law system, which puts him head and shoulders above Mark Means. So where he didn't have experience was specifically in a death penalty case. The specific skills required in a death penalty case have to do with being able to do mitigation and being able to bring the sorts of constitutional anti-death penalty motions that Pryor has been filing, and that Thomas and Archibald filed in Lori's case. So he has been doing all of the things that you would expect someone to do in a death penalty case, which says to me that he's been doing his homework, and he has absolutely been consulting with somebody who is more experienced in death penalty cases. So a lawyer is obligated to educate themselves to a level that they can appear and represent their client competently. They're not required to be experienced in that area of the law. For example, if a new lawyer right out of law school could take a criminal case, their responsibility would be to spend many, many hours educating themselves and getting up to speed on the specifics of criminal law in order to adequately represent their client. That's the expectation that the bar has, and the American Bar Association guidelines say, is that the lawyer has to be willing and able to become qualified in that area of the law. So John Pryor is certainly within the ethical guidelines to say, I've never done a death penalty case, but I'm confident that I can become competent and qualified to represent Chad in a death penalty case. And he's not required by the state to meet their level of qualification because he's not court appointed. Hopefully that answers that question. This question, Brennan Tube, how about Arizona? Could Lori write a book about being in Arizona? I don't believe so, because I think Arizona has a Slayer statute as well. Most states do have a statute. It all sort of came out of the Son of Sam case when he made a bunch of money off writing a book about what he'd done. And most states have some sort of a law that precludes someone from profiting from their crime. Now, there have been some challenges, some First Amendment challenges to that law. But at this point, those laws are still good in the states that have them. And I think most of them do. I'm pretty sure Arizona has a Slayer statute. So she would not be able to write a book while she was in prison in Arizona and profit from it any more than she would be able to be in Idaho. And certainly she would not be able, even if she were physically in Arizona, to write a book about anything that happened in Idaho, because she would be precluded from profiting from those crimes that happened in Idaho, even if she were physically located in Arizona. So I hope that answers that question. I'm going to grab another sip of my wine while we see if we have more questions. I want to say it has been great to see you all. I've missed you all. I love our Wednesday nights, and I love the opportunity to exchange ideas. It makes me think. It makes me a better thinker. It makes my thinking about the case I'm writing about better. So I appreciate it. And I also appreciate the fact that we have we have the best community ever. And we rarely have people who say mean things or you know, I hear about so many other people who, creators who are struggling with mean comments and trolls. And I'm constantly and incredibly grateful that we don't contend with that in our chat. So I appreciate all of you. Alabama wants to know, she charged for courthouse tours. That would be Becky Hill in the Murdoch case down in South Carolina in Colleton County. And the allegation in the ethics complaint is that she was charging for courthouse tours, and that there is no accounting for the money that she charged people to take those. I don't know if she was charging or whether she was soliciting donations in return for courthouse tours, but you get the gist. And she said that it was to support some repairs in the courthouse, but it's unclear if that money's ever been accounted for or how much there was. We don't know, but we know that that's one of the accusations in the ethics complaint. Now, Becky Hill has not been charged criminally with anything. Her son, who is the IT manager for the courthouse, has been charged criminally with wiretapping offense. But Becky Hill has not been charged with any criminal offenses at this point. But we do know that the case has been referred to SLED, the South Carolina Law Enforcement Division, which is their state police. So, good questions. Hey, squeaky wheel. Important question. Have I ever drunk wine to the point that I couldn't remember what happened the night before, like a few of your clients probably have? In other words, blackout drunk. Now, I will tell you that in my youth, I consumed a great deal of alcohol. I do not ever remember being in a state where I did not remember what had happened the night before. I do remember some very ill-advised things that I did under the influence of alcohol. I'm sure that we probably all can attest to that, with a few exceptions. One of my dearest legal colleagues and office mates grew up in a church that doesn't believe in eating meat and doesn't believe in drinking. And this is a guy who neither alcohol nor meat has ever crossed his lips. But I think he is the 1%, and the rest of us are the 99. So I certainly can tell you that I have been drunk to the point where I have done things that I later regretted or that were very poor judgment on my part. But I do not recall ever having been drunk to the point where I blacked out and lost memory. But I do know that it happens, and I certainly have had clients who say they have been that drunk. And I think it's a medical. I mean, I think it's a medical reality that there is a point when you drink so much that your brain just turns off. So. So you're making me fess up, making me make admissions. So, and this is my first glass of wine in more than a month. I think I had a glass of wine at Thanksgiving, so I'm doing pretty well. Hi, Mary Howard. Thanks again for your generosity. I want you to know how much we love you and appreciate you. Information. Donna has a grandchild from Charlie who she totally ignores. That's right. The mother had to take Charlie to court for paternity. Why does Donna only care about Wendy's kids and not Charlie's son? First of all, because Charlie was not married to the mother of his child. And I think that second, she was not someone that Donna Adelson handpicked. And I don't believe she's Jewish. I think that if you listen to some of the other information that's out there, there's a great podcast series called Over My Dead Body about the Adelson case. And I think one of the things that they point out is the fact that Donna Adelson wanted complete control over who her children married. There's no question Charlie was the favored child, but when her elder son, Robert, was involved with a woman who was not Jewish, Donna came down hard and fast on him. She insisted that he break up with the woman, insisted that that he not be involved with her, and that anyone that he married had to be Jewish. He then broke up with the woman he was dating, married a Jewish woman who he had a very short marriage to, and divorced. He then reconciled with his true love, and they married. And as a result, he is pretty much ostracized from the family. He has very little contact with his family at all. He had some occasional contact, I think, with his siblings, not with his parents. He was pretty much ostracized. He was pretty much booted out of the family because of marrying someone outside the faith. So even though they were not nearly as observant and as religious as Dan Markel and his family are, there still was that prohibition against marrying outside their faith. And I do not believe that the mother of Charlie's child is Jewish. And I think that is a huge problem for Donna. So I think Donna was real quick to say, he's not the dad. She's, you know, it could be anybody sort of attitude. And it wasn't until paternity was established and Charlie was ordered to support the child that any of them really acknowledged that he had a child. So Charlie's not married to this woman, and I don't believe she's Jewish. And I think that is the reason why Donna has, as far as she's concerned, that kid doesn't exist. And I think her world revolves around Dan and Wendy's children. They actually moved right after right after Dan Markel was killed. They moved, sold their condo, and moved to a different, bigger condo that had room for Wendy and the children across the street from a Jewish school, from a private school, so that grandma could walk the kids back and forth to school every day. So, I mean, you know, to call this family enmeshed is a horrible understatement. Good question. And I think that's the answer, Mary. Question. In Arizona, they seem to allow juror questions. Any idea if that is up to the judge only? This is a good question. And in fact, in states where they allow juror questions, it usually is up to the judge to determine whether or not they will take questions from the jury. They don't do it in Idaho. I have to do a little bit more research because I have not watched a trial. I don't remember in the Arias case. Did they allow juror questions? Because Jodi Arias was from that same area, would have been tried in that same court. So y'all who remember that, let me know. Because it really is up to the judge as to whether they allow and what they allow. So typically what happens in a state that allows jurors to ask questions is the jurors write their questions down on a piece of paper and they pass them to the judge, and the judge reviews them. And if the judge finds that they are appropriate questions that can be asked within the bounds of the rules of evidence, then the judge will ask those questions. But the judge still ends up being the final arbiter on whether or not they are appropriate within the rules of evidence, because even the jurors' questions still have to comply with the rules of evidence. So that's a good question. So if anybody remembers whether they allowed questions in the Arias trial, I'd be curious, because that was so long ago, I honestly don't remember. And I only watched bits and pieces of it. I don't think I watched the entire trial because I was still practicing and busy. Other questions? Hi, Beth. But then Donna told Wendy to send the boys to Catholic school unless Dan allowed her to move. It seems that Donna is Jewish when it suits her. Yeah, I don't disagree with that. She also told Wendy to dress them up as Nazis for Halloween. So I think that she was willing, and I think this is really troubling. What troubles me about these comments was she told Wendy, we'll just have the kids convert to being Catholic, and that will make Dan insane. And you can dress them up as Nazis for Halloween. That'll make Dan insane. Without any kind of consideration to what that would do to these children, what an impact it would have on them. I think that's a pretty cold-hearted, narcissistic way to look at the world, to look at these children who she claims are her heart and soul and be willing to use them as pawns without any consideration of their feelings or what sort of trauma or impact it's going to have on them. These are children whose identity is that they're Jewish. And yet she was willing to rip that away from them to get even with Dan Markel. So I think that speaks volumes about Donna and who she is. And I don't disagree that I think she's Jewish when it suits her. And I think demanding that her children all marry people within the faith is just another control mechanism for her. I'm uncertain about how devoutly Jewish she is, but I certainly know that she's all about appearance, and that within the community, it's not looked on well to marry outside the faith in some Jewish communities. So it may very well be that it was much more about appearances within her community than it was about her true feelings. I don't know. I don't think we know enough about Donna Sue yet, but I think we're going to learn an awful lot about her. We're coming up on the end of our 2-hour stint. So anybody, if you've got last questions, please get them in the chat. In the meantime, I'd like to say thanks once again for all of your support. Thank you so much for your generous support tonight for Michelle and her family. Thank you so much to Jen, who is the moderator and admin for our Facebook group called The Good Lori. And I thank you very much for doing that. And Jen has been kind enough to step in and be our backup for Michelle's moderating job duties for when she's feeling under the weather. And I appreciate that so much. Once again, I apologize for last week. We just let things get away from us, and I wasn't aware until just before it was time for the program to launch that Michelle was really sick. And so now we have some contingency plans in place, and we'll work really hard not to let that happen again. So thank you all so much for being with us tonight. A couple things to remind you: wristbands are still available. The Justice for Tylee and JJ wristbands are still available. The address to send your self-addressed stamped envelope is in the chat. I do have a few that I need to get winged on their way, and I will try and get those out. Certainly, we haven't been getting the bulk of requests that we did early in the case. But don't forget, we have another trial coming up, and I think it's important for us to continue to seek justice for Tylee and JJ and Tammy and for Charles as these cases go forward. So I appreciate all of you who have sent requests. If you'd still like one or you need a replacement, just drop me a self-addressed envelope. So with that, I think we're going to say goodnight. Thank you all for being with us. Thanks for joining us. And we hope that you're going to have a great week. I am going to be gone over Christmas, so I'll put out a schedule and let everybody know when we'll be on and when we won't be. But we've got a couple of weeks before that happens. We have at least one more week before we'll be looking at the Christmas holiday. So I hope all of you are enjoying the run up to the holiday. I'm excited. We're going to take my mom out for a little drive through Christmas lights this week. She's looking forward to it. And so I'm wishing you all a great week. Have a great weekend. And we'll see you here next week. Good night.